Welcome to the Law, Politics, and Media speaker series. Today we host the fifth speaker in the series. For those who are our guests and for the tape, the series is produced by the Institute for the Study of Judiciary, Politics, and the Media, which is based here at the College of Law and is a collaboration with the Newhouse School and the Maxwell School. A note about the procedure here. We'll be passing around a sign-up sheet for our students, and our students have name tags to help the speaker identify them when she calls on them. But we welcome questions from students and guests alike after the speaker has given her presentation, which would probably be at about 4:30, and we'll take it up to 5 o'clock, at which time we will adjourn to the hallway for a reception. So I wanted to let everyone know what the procedure is today. Previous speakers in our series have included a media lawyer who worried that misbehavior by journalists would lead to troublesome court decisions, punishing the media. We had a former New York Times reporter who stressed the importance of investigative reporting, holding the courts accountable. Today's speaker comes from yet another angle, from yet another camp in the law, politics, and media triumvirate, an attorney who serves as a commentator on television. And as we all know, these commentators come in various flavors. They're either journalists with an interest in the law or training in the law, or practicing lawyers who comment on the goings-on in the law. And that is, in fact, our speaker's background as both a practicing lawyer and a TV commentator. Midwin Charles has her own law firm in New York City and is a regular guest commentator on CNN Headline News' Nancy Grace Show and Showbiz Tonight. She also appears on True TV, formerly Court TV's Open Court, Best Defense, and Courtside. She has appeared also on Fox Business Network and MSNBC. As a practicing lawyer, Ms. Charles started at Fried Frank, an elite Wall Street firm, in litigation, and that remains her focus in her own firm, including criminal law. She is an alumnus of Syracuse University in international relations and attended got a law degree from the Washington College of Law at American University in Washington, clerked at the Sixth Circuit, and was the Leon Higginbotham Research Fellow in Social Justice at the Harvard Law School under Professor Charles Ogletree. We're grateful to her for braving the frigid weather and the New York City air traffic control, and grateful that we finally have a speaker who's comfortable in front of the camera. Please welcome Midwin Charles.
Thank you very much. I'd like to thank you guys for inviting me here to IJPM. This is quite an interesting course. As I said earlier today during lunch, this is quite a intersection of law, politics, media, which I think is really what you see happening whenever you turn on your television or pick up a newspaper. You can't help but escape it. But the topic that I'm going to talk about today is the impact of media coverage on a defendant's right to a fair trial. Now, I'm sure a lot of you are familiar with what's been going on with the TV and the news and the media. But I'd like to start by first telling you a story. Imagine for a second that you're a college student. And you're one of the cool college students because you're young, you're rich, you're attractive, and you're a member of the lacrosse team. And as a member on this lacrosse team, you guys like to party. And every once in a while, you'll throw a party and you'll invite a dancer. So imagine you go to this party, everyone's having a good time, party's over, next thing you know, you are being accused of rape. You are arrested, you're fingerprinted, your face is all over the media, feminists want your head on a platter, faculty wants you gone, your lacrosse team, gone. They've suspended the season. You're called racist. You're called privileged. You're called spoiled. And most importantly, the district attorney believes you did it and will stop at nothing before getting a conviction. Such is the story of the Duke rape case that I'm sure many of you are familiar about. 3 students were arrested, and the charges were forcible rape, sexual offense, and kidnapping in March of 2006. Now, the Duke rape case had the trappings of a wonderful story. You had sex, you had race, you had class, and you had politics. Outrage from the media abounded. Faculty groups rallied. Should the students be suspended? Should they not? You had students come out in support. You had students come out against them. The community, you had African Americans come out and say that these students had to go. And you had a prosecutor who decided that these students did it no matter what. Now, what made this case interesting is you had a prosecutor going full steam ahead in trying to prosecute these 3 students, despite the fact that DNA evidence submitted by the entire lacrosse team did not match the DNA found on the victim. This information, as many of my law students here know, is exculpatory evidence. And as you know, prosecutors are required to turn over evidence that they believe will exculpate a defendant. They're supposed to turn it over to the defense. Naifong didn't do that in this case. There were tons of inconsistencies in the victim's story, as well as unimpeachable alibi evidence provided by 2 of the 3 accused. The police department in this case allowed the prosecutor to act as a de facto head of investigation, giving a suspect photo identification procedure to the victim. Mike Naifong, who was the prosecutor in this case, pursued the case despite discrepancies in notes taken by an investigator and a sergeant. After a year-long nightmare that these students went through, the North Carolina State Attorney General, Roy Cooper, dropped all charges. Naifong was disbarred for dishonesty, fraud, deceit, and misrepresentation, making him the first prosecutor in North Carolina history to lose his law license based on actions in a case. Naifong was found guilty of criminal contempt and served 1 day in jail. So what's the dilemma? The Sixth Amendment of the U.S. Constitution provides in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. Now, the First Amendment says, Congress shall make no law, ... abridging the freedom of speech or the press. Now, in looking at these 2 amendments of the U.S. Constitution, no one ever said which was more important than the other, right? These amendments aren't ranked in order of importance. Media coverage now. In recent years, the media has covered criminal trials or the accused with a zest for entertainment. I mean, who can forget the coverage of the O.J. Simpson trial, which began with the police chase of that white Ford Bronco? It was riveting. We now live in a time where reality television, cable networks, blogs, internet websites, and tabloid magazines cover criminal cases ad nauseum, particularly when they involve murder, race, sex, and suspense. Of course, if the defendant is a celebrity, then the coverage is even more intense. In covering these cases, some might ask, well, what's the big deal? The media has the right to cover these cases. They have the right under free speech, First Amendment, and some have even said that they have a derivative right from the Sixth Amendment where it says public trial. But here's what the media does now. You've got up-to-the-minute reports on all aspects of a case, including live, exclusive coverage coming to you live at 6 p.m. You've got footage of crowds screaming for the blood of the accused, camera crews stationed outside the home or office of the accused, media outlets going to court to seek access to autopsy and coroner photos, and reports in the name of public interest. You've got interest and media groups conducting their own investigation and making their findings public in a manner that such findings would never meet the strict scrutiny of a court and be admitted into evidence. Tabloids will print any rumor, and the stories will jump quickly into mainstream media. So now you're seeing a role reversal here. Tabloids first, then mainstream media. I mean, how many of you have heard CNN or your local news reference TMZ as a source of information on a case? But the question is, does this round-the-clock coverage affect an accused or a defendant's right to a fair trial? you have to always ask yourself, which of the two amendments that I talked about earlier is most important? Are the rights extended to a defendant by the Sixth Amendment, do they outweigh the exercise of free press rights? The tension between these two amendments, between free press and fair trial rights, it begins with minimizing the prejudicial effect of the coverage, right? Because that's really what's at essence here. Is this coverage prejudicial to a defendant? Is it prejudicial to someone who's not even a defendant yet? Someone is just doing something untoward, has caught media attention, and the cameras go ablaze. Is it prejudicial? Courts have never defined freedom of expression as an absolute right. Instead, the Supreme Court has held that freedom of expression should be restrained in some circumstances to protect a defendant's right to a fair trial. So basically, under current law, there is in fact a legal basis for restraining the media, since when the exercise of free press rights actually tramples upon Sixth Amendment rights, the former must yield to the latter. The problem now, however, is that the press is not necessarily constrained. Media's use of First Amendment has detrimental effect on the criminal justice system. Unlike lawyers who are regulated by strict professional codes and guidelines enforced by their state bars, and the press's code of ethics is voluntarily followed with no formal enforcement mechanism. So basically, in a lot of cases that are reported by journalists or the media, they pretty much can say anything. They really don't get to have that kind of scrutiny that lawyers do when presenting evidence in court. You now have a point where objective reporting has now become subjective fact reporting. But most of us will say, well, so what? How does this affect our criminal justice system? Well, the media has an effect on jury bias. Remember that whole part that I started with the Sixth Amendment, the impartial jury part? That's really what's at key here. Sociological studies have linked pretrial publicity to the likelihood of a biased jury. A study found that the more pretrial coverage a person is exposed to, and the more likely that the person will know about a given case, the more a person knows about a case, the greater likelihood they will form a biased opinion about the defendant. Before trial has even started, before evidence has ever even been submitted into a court of law, you have potential jurors already forming a biased opinion. Now, what makes this all the more interesting is you are now seeing a rise in lawsuits of criminal defendants. Criminal defendants who have been found guilty of crimes are now appealing on the grounds that they were not given a fair trial as a result of jury bias or prejudicial pretrial publicity. Now, oftentimes we talk about, well, you have this media attention on people who are accused or people who are in the media but not necessarily yet arrested. But what happens when you do have a defendant who is on trial? How does a judge protect that defendant? How does a judge ensure that that Sixth Amendment right is there for the defendant? Trial judges basically have an obligation to assure that defendants receive a fair trial in which an impartial jury determines their guilt or innocence. Judges can do this in a lot of different ways. They can enforce gag orders on trial participants, voir dire, which a lot of my law students here know what that is. That's when you start to question potential jurors before a trial begins. Jury instructions. You can sequester a jury. You can postpone a trial or change a venue. But the problem is a lot of these remedies have lately been rendered ineffective. And that's because of the way information is now disseminated in our society. Information is so rapid and so instantaneous that even if a judge were to change the venue of a trial, it really doesn't matter. Because if a crime happened in LA and you move it to a different county, what difference does it make? The problem is the information is already out there. potential jurors have heard it, and most likely they would have formed an opinion as to the guilt or innocence of the person. If any of you guys watch any of the shows that cover some of these cases, you will see the number of people calling in. If you watch Nancy Grace or Greta Van Susteren or even Anderson Cooper on CNN, they literally say this person did it or they didn't do it, and that's it. And they will discover information and have their own investigation and pull information that, as many of you know as lawyers, would never, ever, ever be admitted into a court of law. It just would never, pass the rules of evidence, whether it's because it's hearsay or it's overly prejudicial to a defendant. Now, intense media coverage, one of the biggest problems with it is that it makes the public think that they themselves are the jurors. And by extension, they feel that they can take the legal system into their own hands. When you often look at examples such as Caylee Anthony, the Rodney King case back in 1991 when the police officers were acquitted, there was so much coverage of that case, and so many individual people felt that they were a part of the trial. Even though they were not sitting in the courtroom every day, even though they were not privy to the details that the jurors were privy to, or the details to which the judge were privy to when the judge ruled on each and every motion and each and every objection. Yet, when a decision comes down, the public feels as though, you know what, I heard all the evidence and I know this person is guilty. So what happened? If you look at the Rodney King case, when those LAPD officers were acquitted, people took to the streets and rioted. And that's one of the biggest problems with this media coverage that we have today, is that you have people thinking that they themselves can be arbiters of justice. And if you look at if you follow the Caylee Anthony case, you'll see people camped out outside of her parents' home, yelling and screaming. If you take, for example, the case that I spoke about earlier today during the lunch discussion, the woman they are calling Octo Mom, Nadia Suleiman, who's the mother of the 8 children, people are absolutely outraged because this woman had 8 children and she already had 6 at home. Well, the question becomes, has she done anything illegal? And if so, has she been arrested? The question is no. But yet 2 or 3 lawsuits have already been filed to have the 8 children removed from her home. So those are basically the problems that we have with this abundant media coverage. You have a chilling effect of defendants' rights when they are going to trial because you have all this information out and it affects the jury pool. And that's one of the hardest things that you can do. And if you look at cases where the defendant is a celebrity, then forget it. The problem is even more intense and even more ramped up. Now, some scholars have said, well, you know what, this isn't that big a problem because these kinds of high media profile cases, they're few and far between. But the justice system doesn't operate that way. It doesn't say that only a few people should kind of fall beneath the radar and not get a fair trial simply because they're few in number. The justice system says that every defendant should get a fair and impartial trial, and every defendant should have a public trial. So judges are working overtime and working really, really hard to make sure that this happens. Part of the problem is that the justice system is often 4 or 5 steps behind in trying to deal with advents and innovative ways in which information is disseminated, right? Who would have thought that an outfit like TMZ would exist today, an outfit that can go and find photographs of, say, for example, Rihanna, the pop star who was allegedly beat by her boyfriend. You know, you have people out there now who are actually paying for things that are or are not evidence. An investigation is still ongoing. So you have to ask yourself, how do these actions impact the ongoing investigation? If you look at the Duke rape case, that too was an ongoing investigation. There was so much media outrage with that case, with people calling for the heads of these 3 guys, that the prosecution ignored evidence, obvious evidence that exculpated these guys. I mean, it's very difficult for you to walk away from DNA evidence. And that information was held back, and that prosecutor forged forward. So again, you have media coverage, you have outrage from the public impacting how a prosecutor dictates his or her case. And in that case you saw, Mike Nifong was eventually disbarred because what he did was so egregious and did not comport with the law. So that's one of the biggest problems that we have right now. There was a case that I did want to cite to you guys that I thought was very on point in this case. Yes. If you look at some of the case law that's out there, the Supreme Court has been dealing with this issue for a long time. But like I said, they are oftentimes behind in trying to figure out how to deal with this fast disseminating information. In 1961, in Irving Vidal, the Supreme Court for the first time struck down a state conviction solely on the ground of prejudicial pretrial publicity. So there is precedent out there for a criminal defendant to go ahead and turn around and allege that they were not granted a fair trial because of pretrial publicity. But you could just imagine the kind of information that an appeal would have to put forward and the kind of studies that such an appeal would have to put forward. Because you basically have to prove that there was so much information out there that it was virtually impossible for the person to get a fair trial. Now, judges may try to postpone the trial and hope that the media coverage will die down. Now, sometimes that happens, sometimes it doesn't. Oftentimes, people will kind of relive the moment as the trial date approaches. But if something interesting is happening in the media, then that case might be kind of knocked to the wayside. So it's quite an interesting thing. Quite an interesting thing to see how that plays out. So that is what I have. Yes.
So when a booker from one of these shows calls you and says, we want you to talk about this pending investigation, we want you to analyze where it's headed, what's a commentator to do? Is there a solution in your hands that would make this situation better, that would make the coverage more responsible, or just say no?
I'm a defense attorney. That's my training. It's how I think. It's how I'm wired. So every time I'm asked to comment on one of these kinds of cases or any of these kinds of trials, my instinctive reaction is always to wait until we see what the evidence is. And Nancy Grace is tired of me because that's always my answer. But I don't care because that is how the justice system works. But to answer your question, I usually say we have to look at whether, of course, assuming that these investigators are properly trained and properly executing their duties and doing everything that they can do to find the information, is so let's wait and see what they come with. Let's wait and see what these investigators uncover before we start making a determination as to what is fact. You see, because that is the biggest problem. There is now this assumption, there is now this mechanism by which we operate under what is fact and what is not. And only a court of law in these kinds of cases should determine what is fact based upon evidence that is submitted in a court of law. And that is how people arrive at their conclusions as to whether or not someone is innocent or guilty. And in all of this hoopla, we forget that the system is premised upon the fundamental fact that you are innocent before being proven guilty, not the other way around. You are innocent until proven guilty. And that proving someone guilty is a very, very hard thing for a prosecutor to do. And they've got to work to do it, and that's how it should be. Yeah.
Hi, I'm a grad student in journalism in Newhouse, and there's a few other Newhouse students here. I feel like you're more about, you're saying that we should not cover the trials. I feel that, how do you balance our right to cover trials and the right of the public to have that information? Because you seem to say that for them to have a fair trial, we shouldn't cover
No.
trials.
Yeah, no, I'm not saying that there should be no media coverage. That is not at all what I'm saying. What I'm saying is that the media coverage should not be so incessant and in a way where it tramples upon the rights of a defendant to have a fair trial. In other words, no stalking the wife of the defendant. You understand what I'm saying? No interfering with the process of law. If a reporter truly wants to cover a trial, then they literally will cover a trial and say, today the defense will bring these witnesses. Tomorrow the prosecutor will bring these witnesses. But that's not at all what's happening now. What's happening now is you have reporters actually acting like defense attorneys and prosecutors and getting coroner reports and posting them on websites and saying, look, if you look at page 5, the coroner said that drugs were found in their system, therefore it was an overdose. And so you have people now starting to formulate fact before you're even in the court of law. So it's not at all that I'm saying that the media should not cover these trials. That's not at all what I'm saying. What I'm saying is that the coverage needs to be responsible, and journalists really need to kind of rise to the occasion when it comes to covering these trials in a manner that is respectful to the defendant's rights.
Now that this kind of coverage is what we come to expect of these cases, and you can see that there's a lot of popularity on Nancy Grace for the Kaylee Anthony trial and all of her dramatics. How do you roll back the coverage? How do you go back to a time when it was the media coverage was less intrusive and less, hurtful to the defendant's rights?
That's a good question. I don't know that you can. I don't know that you can, because one of the things we talked about during the lunch today is that this stuff sells. It's what people want to hear. So it's quite an interesting take on where we are as a society today. People love what's salacious. They love what's sexy, And so you have to ask yourself, where are we going as a society if we start to make assumptions and we start to determine who is innocent or guilty before we even get into a court of law? But, I really don't know. I don't know how you roll it back. Who is going to be responsible for telling CNN, do not continue to post pictures of Kaylee Anthony partying when her daughter was missing, because you are, creating this element of innuendo and assumption as to whether or not she played a part in the missing of her daughter. Who holds CNN accountable for doing that kind of stuff? I don't know. Yeah.
I'm just curious, what do you think is the goal, or actually let me rephrase that. What do you think is the media's goal? Not what you think their goal should be, but what do you think their goal is?
In terms of what? In terms of how they cover stuff now?
In terms of when they cover something, or when they're fulfilling their quote-unquote role as being media and informing the public, what do you think their actual goal is?
Now I think it's money. I really do. I really do. And I was saying in the lunch earlier today that, the last couple times I did the Nancy Grace show, we covered the Kaylee Anthony case 3 months in a row. And every time I get there, I'm like, I can't believe we're still covering this case. Can you, talk about something else? There are thousands of children missing in this country, that need the same attention. And the producers are like, this sells like hotcakes. Our ratings go through the roof. People love it. People love it. And now you have, I think for me what's interesting with that case is you had a child who was missing. You had a mother who was not acting the way people thought she should act. And you had various different media outfits who followed her, who harassed her parents for months. And then all of a sudden she was indicted. But throughout the months where she and her parents were followed, you had photographs that were made public of her acting in a way that a mother is not supposed to act. You had all kinds of statements that she made. You had bizarre actions on her part. And so you have to ask yourself, well, did this kind of assist the prosecutor? Did the prosecutor kind of feel pressure to kind of push this case forward and try to get an indictment? So you see, those are the kinds of questions that we have to ask ourselves. And that's why I always like to start with the Duke rape case, because that's a prime example of how intense media coverage, in the way it was with the Duke rape case, can sometimes encourage a prosecutor. You know, I have all this pressure to prosecute, to kind of look the other way, even when the facts are staring him in the face that this person probably didn't do it. But in order to appease the media and the public outcry, you get a prosecutor who is on the verge of committing prosecutorial misconduct. Yeah.
I wanted to bring up another point. It seems to me that what you were saying is you have this judicial system that's trying to have a fair trial and a press that isn't always allowing the justice system to do its job. But I want to give an example of a case here in Syracuse where the prosecutors had decided on the guilt of a person here. It was a Muslim daughter, so at national and state level they called him a terrorist. He was held without bail for 31 months. They never charged him with any terrorism. He was charged as a white-collar criminal. And yet the newspaper took everything that the government fed it, never challenged the government, put out the headlines about terrorism. And you know, that is another major concern, because that's not just happening here in Syracuse, that's happening across this country to Muslims. This is a major new area where people are not being given a fair trial.
Right.
And you know, even at the appeal level, this man, Dr. Dafir, he can appeal the fact that just before the sentencing, the government told the paper he's got ties to terrorism. Even at appeal in the courtroom, he can only use what the court records are, which is purely white-collar crime.
Right.
And Governor Pataki announced just before the start of the trial that funders of terrorism were going to be brought to justice. But he's never been allowed to answer that charge in a court of law. And, I mean, can you speak to that? The fact that the government also uses the press, and the press is willingly used.
That the government uses the media?
Yeah.
Oh, yeah. I mean, unfortunately, you had a lot of, since 9/11, you had a lot of curtailment of civil rights of mostly Muslims, but various different people whose civil rights were curtailed for a variety of reasons. And unfortunately, we were at the time, hopefully this new administration will be different, but we were at a time where it was acceptable to do that. And you had a lot of attorneys and a lot of attorneys groups who marched against that and who felt that, you know, the minute you start letting civil liberties go, it's a slippery slope. You let some civil liberties go for one group, next thing you know, it goes for another group. So it's unfortunate that that happened in that case. Unfortunately, a lot of those cases happened, especially after 9/11, and I'm hoping that those are the last of those cases. Yeah.
I was wondering if you could comment about a phenomenon that sometimes seems to be happening, where it's not just media pressure on the legal process, but individuals who see the opportunity or see a celebrity trial as an opportunity. I was on the jury, and so
Oh,
I got a
yes.
book deal.
Oh, yes. Oh, yes. Oh,
And
yes.
So do you think that from one, do you think that does happen? And how do you think, two, what do you think could be done to address that phenomenon if it is a phenomenon?
You know, that's one of the hardest things to do, because remember I talked earlier about the studies that have shown that if a potential juror hears a lot of pretrial publicity, that they would have already formed a biased opinion. But now we're also starting to see where you have jurors who are lying during voir dire. So during the process where the opposing counsel and the judges will ask potential jurors, what do you think about this defendant? What do you think about this case? They actually lie so that they can get on the jury and hopefully convict that person. You have a lot of that going on. And I don't know how you kind of prevent someone from doing that. Unfortunately, we're now living in a society where there's so much opportunity that, you know, even if you do something wrong, you now get a book deal. Like, people are rewarded for bad behavior. It's just so bizarre to me that that's the kind of society we're living in. But I don't know. I mean, one thing that a judge can do is say that, okay, fine, you want to get this book deal, but you're not going to be able to talk about aspects of the trial because they're protected. That he can potentially put a gag order on that, but it could be difficult to do in the long run. Yeah.
In preparing for today's class, I read a couple of your articles. You had
Oh,
written one
Lord.
was Revenge of the Wives.
Yeah.
And I guess I was surprised to listen to your talk today, which mirrored more of Mark Garagos's law review article, because it almost seemed as though in Revenge of the Wives, the fact that these women wanted public media trials was a good thing because it helped their case. And it wasn't revenge per se.
No, it wasn't.
But it was a good that they used it because it helped them get the judgment they wanted.
Right.
So I'm wondering how it's, maybe we don't look upon that as a bad thing, but those, because maybe it's a divorce case and not a criminal trial.
Right.
So there could be a difference in opinion there. But I guess I just really was surprised almost to hear your speech today after reading those articles.
Yeah, there was a difference. And the main difference with those cases is, A, like you said, they're not criminal trials. B, with those cases, the women in those cases were trying to get child support and alimony. C, those kinds of trials, for the most part, they're already public, right? So they didn't do anything wrong in trying to ensure that they remained public. The reason why I wrote that article is I was trying to address the flack that these women were getting for a quote-unquote public trial. The point is the trial is already public. The flack they received is because the salacious information about what their husbands had did was rehashed as a result of the child support and the divorce trial. But the point is, those things that the husbands did were already in the public. So they didn't do anything new or wrong by trying to get their matters dealt with in a public forum.
Yeah.
So you see what I'm saying?
I know, I did, and I
Yeah.
was reading the Garagos Law Review article I saw too. It's kind of like, he even says it's okay in a quid pro quo kind of fashion in a criminal sense. You know, the prosecution's going to have a press conference and talk this. The defense counsel then should be able to rebut those or talk at those issues.
Right, and that's what you see now. That's what you see now. When a prosecutor is about to indict someone, or when the prosecutor has a press conference, that never used to be the case. And now you have the defense attorney having a press conference.
Exactly.
So it's interesting because we are on a roller coaster right now. We don't know where this is going to lead to. But it's something that we need to keep an eye on, and we need to kind of recognize how is this affecting the defendant. Whether the defendant is a rich multimillionaire celebrity or whether the defendant is a regular person who has done something that is salacious and therefore constantly in the media eye and the media attention. Yeah.
Do you see an upswing of civil suits as a result of things that happen? I remember there was that To Catch a Predator incident where the prosecutor shot himself and all the people were at his house, pounded on his doors. I don't know if you remember that. It was a couple of years ago.
No, I don't.
Remember that? To Catch a Predator, there was a prosecutor in Texas. To Catch a Predator said there was one little incident. Supposedly he was involved. There wasn't. Nobody really knew. No trial. To Catch a Predator published it all over, said all this stuff. So people started going to his house. The police went to his house, and he shot himself. I mean, the guy was an attorney, all this stuff. And then they brought a lawsuit, and I think NBC ended up settling or something. There was a whole thing. Do you see that happening in the future as like an outcry or outlash or a backlash against this, or do you think that'll a one-time incident? Do you see that as a potential harm? Or?
It's definitely a potential harm because what we're noticing now is the coverage is now becoming mainstream. Initially, this kind of coverage was just what you would call tabloid. But as I was waiting in the lobby for Kyle to pick me up, I was watching CNN, which is a reputable media source, right? And it was nothing but Kaylee Anthony and how she's going to be brought to court in about 2 hours, and did she do it, and did she not, and but I think that that's a concern because he shot himself because he knew that he was going to be subject to the scrutiny of the media in a way that is so intense and so intrusive, he probably didn't want to deal with it. That is so unfortunate that someone would take their life because they know that this is what's coming. This is what's coming down the pike. Yeah.
You've been asked and talked about that there may not be a solution, or what the solution is hard to get to. It would seem to me that, at least theoretically, a solution might lie, assuming that, say, the court were persuaded that there was a significant enough problem, in reinterpreting the First Amendment, in reinterpreting the Sixth Amendment, along the lines that you've suggested. And I guess, particularly if the problem of information, the problem, the phenomenon of information dissemination continues to grow.
And it will grow.
And so, I guess my question for you is, do you think there is room for a gradual or sudden, perhaps not sooner, but maybe later, reinterpretation of the First Amendment in light of the Sixth Amendment? I mean, how likely do you think that is, if at all?
I don't know.
I mean, obviously, the First Amendment says what it says, but there are limits on First Amendment.
There are.
All kinds of
There
limits.
are. You can't
So
cry.
Congress does make laws.
They do. They do. I mean, you can't cry, fire in a crowded theater or whatever. So there definitely are things that you can and can't say and what have you. I don't know. I don't know. I mean, you've already had the Supreme Court speak on this issue, like I had mentioned in the 1961 case, where they had said that, they did overturn a conviction because, as a result of pretrial publicity, where they felt that the defendant was deprived of a fair trial. So it's one of those things where I don't know if they'll revisit it. But if things continue the way they do, they just might. Especially if you start seeing different rulings in the different circuits. Because one issue that I didn't even talk about yet is cameras in the courtroom, which is a whole different thing, and how that affects a defendant's right to a trial also. And the Supreme Court has not spoken on that yet. You have different jurisdictions with different rules. Some jurisdictions say yes, some say no, but it's up to the judge's discretion, so it's all over the place. So I think that might be possibly where the Supreme Court might be headed on this issue, cameras in the courtroom, and deciding how that plays a role in a defendant's right to a fair trial.
Do you have an opinion on that one way or the other that you'd like to share?
Oh, Lord, is CNN watching? I don't know. I'm actually going to be on True TV tomorrow, and there are a lot of court opinions out there that say, so long as the camera is unobtrusive, right? In other words, you turn it on and you walk away like this camera is on right now, that it really doesn't impact the defendant's right because trials are public anyway. And they do that so that we can all be, encouraged that our judicial system is working and that a defendant isn't being tried by some secret tribunal, which is how our justice system is set up. So I feel that having a simple camera in that's unobtrusive is fine. I do. And I'll get a copy of that and burn it. Yeah.
You talked a little bit about the public seeing themselves as jurors, and specifically in terms of bloggers and citizen journalists. You talked a little bit about how lawyers are, held to standards by the Bar Association. Do you believe that there should be such a thing as a licensed journalist, that we as journalists should have to answer to some sort of regulatory body?
It's funny because when I was researching this issue and looking into this, I was amazed at how much the media or journalists can get away with, and there really isn't no governmental body. And the reason being is they don't particularly directly have someone's liberty in their hands, right? I mean, one of the reasons why attorneys are subject to these rules of professional code and ethics and all that is because you have someone's liberty in your hands, right? When Mike Nifong in the Duke rape case was disbarred, it was because he played with these three guys' liberty, and for a year they were pretty much held hostage. And with that horrific accusation over their heads that they were rapists. And so I don't know how you go about that. I mean, I don't know if the journalists in the room can speak to that. I know that you guys have standards when you report. I think you have to check your sources or have 2 credible sources or what have you. I don't know. I don't know. But the trend is with courts. I know in California, I actually had seen this. I know that in some cases, journalists don't even have to divulge their sources. So, I don't know. Yeah.
The idea with cameras in the courtrooms, as some have said, is that it'll give the public a more realistic view of how the court process works. But I'm curious, during your appearances on True TV and things, how you've seen footage from trials maybe used in a way that would be negative to defendants' rights. And the example that I can think of is we recently had a murder trial here in Syracuse, and the footage that they kept playing on TV over and over again was the prosecutor yelling at the defendant when she was on the stand, and that didn't, you could argue that that was the perception that people got of what the trial was like.
Right.
So I'm just wondering how you've seen clips when cameras are permitted in the courtroom, how you've seen those utilized during segments maybe that you've been a part of.
With the cases that I've covered on True TV, the camera hasn't been on for just small snippets or what have you. They're usually on for the entire trial, with the exception of commercial breaks or what have you. It's difficult to say. One of the things is, if a person is not there for an entire trial and not there to hear every witness testify and judge their credibility, not there to look at the evidence that's submitted and determine whether this is in fact good evidence, is it credible evidence, is it circumstantial evidence, it's difficult for you to kind of form a really, really informed opinion as to the guilt or innocence of the person. But having snippets of the trial and playing it over and over again, yes, it plays to people's sensibilities and what have you, and it kind of gives the impression that this is all that happened in the trial, and therefore this person is guilty or what have you. So clips of the trial can definitely be manipulated and taken by someone in order to kind of give the effect that they want. So I could see how that could be problematic, but if you're looking at it in the larger sense where the camera is just turned on and the entire trial is videotaped, I don't see how that's a problem. Especially since all the trials are taped already, right? Audio, right? You have the stenographer and all of that kind of stuff. The problem becomes, do the witnesses, do the district attorneys, do the defense attorneys all feel as though they're putting on a show because the camera's on? Like during the OJ case, I know Judge Ito, Prosecutor Marshall Cross had come under a lot of scrutiny for grandstanding. And were they questioning witnesses because they wanted to perform, or was it because they really wanted to get to the truth of the matter? So there are definitely arguments for both sides, but I think having the camera in the courtroom is fine.
In context of what you just said, do you always try to watch every detail of a case before you make a comment on it? And how does that work and operate with you working with other cases as well? And when you're asked to make comments on cases, do you make sure that you've heard every defendant and every argument, every objection, and all of that?
Only if I'm going to comment on the evidence or the strategy of the defendant or the prosecutor. But oftentimes when I comment, I'm not particularly saying that this person is right or that person is wrong. I'm talking about how does this case impact society? What does this case say about pop culture? If we allow the prosecutor to go down this line of reasoning, how does that impact, the issue at hand? Like one of my biggest things, one of the things that I've noticed with all the trials that I've covered on Court TV is you're seeing a lot of defendants with mental health issues. So oftentimes, I don't need to know every fact about the case to comment on the state of mental health in this country and how people with mental illness are treated and how it's not a sexy disease, it's not cancer or AIDS, and so people with mental illness have a stigma. So I comment in different ways, which is why, with your question, it's a good one, and I totally understand what you're saying, but if I'm commenting that way on society and pop culture, then I don't need to know everything about the case. But if I'm commenting on, is this particular evidence accurate, then yes, I do make sure that I watch all the testimony or read the transcripts. Yeah.
You talked about the justice system being like 4 or 5 steps behind, dealing with new ways in which information is disseminated. Do you see it like catching up at all, or is it just going to be like a constant sort of gap that just keeps sort of widening?
I think they're catching up. I mean, I filed a brief the other day in federal court, and I had to do it electronically. just a few years ago, you had to be making copies of briefs and binding, and so they're catching up. I think the federal government is getting it together in terms of electronics and what have you, and I think that different jurisdictions are faster than others. If you look at jurisdictions such as California and New York, where things might happen a little bit faster, the judges are dealing with these issues day in and day out. So it's possible that they might catch up. Yeah.
In terms of defamation, it seems to me that it's expensive to pursue defamation and takes a lot of sophistication in terms of control of the whole context of a defamation case. And for those reasons, it seems to me that there's a lack of control of damage to defendants in terms of their reputation, because there isn't a way to defend against it in a practical realm unless defamation is somehow incentivized, or enfranchised. And the other comment I have is that taking high moral ground, if the public, with the use of a tabloid-type mentality, seeks to take high moral ground and point its finger at people who sin, let's say sin or do evil, I think we have to police ourselves, individuals. I don't think the tabloids are going to stop doing what they're doing, necessarily from outside pressure, but I see it as kind of loose liberty if we allow ourselves to waste a lot of our attention being drawn into dramas in which we have little part and little effect, and are gratified by a willingness to get into a herd mentality of taking scapegoats, of pointing at scapegoats and saying, oh, look, that person was so terrible.
Right.
And then talking about it like that, I'm on higher moral ground.
Right.
I think it's wasteful is what I'm saying. It's a wasteful process.
Yeah, well, like I had said, it says a lot about society. I mean, I keep mentioning this case because it baffles me, the Kaylee Anthony case. Why would someone who does not know this family think it's okay to camp outside the home of the parents of this young woman? Like, what is it that makes you think that you are doing anything by literally camping out and following the parents who are already dealing with an ordeal of a missing child? And that's what's interesting. And so the question becomes, well, from the media perspective, well, this is already happening. All we're doing is turning on the camera and letting people see it. The people are already there. We didn't force them to be there. We didn't tell them to be there. So it says a lot about our society that people would even feel the need to do that.
I'd like to ask you about the gag rule when a judge...
Gag order.
Yeah. Well, I always thought that was for people outside the trial, that they wouldn't talk about. But there's also one in the trial where a judge can say you cannot use the word terrorism in this trial. I mean, that's what happened to Dr. DeFeer. He was publicly labeled a terrorist outside by the government officials, and then inside the trial he was not allowed to defend himself against that because the judge said you cannot use the word terrorism in this trial.
I'm not familiar of the use of gag order in that form. The form that I'm speaking about of gag order is when during a trial a judge will give an instruction to members of the jurors to the attorneys, the defendant, and say that you are not to speak about this particular issue. This issue is, within the confines of the courtroom, and I am issuing a gag order on it. And should I find out that anyone is talking about this issue, then you will be held in contempt of court.
That would be outside the trial, though.
Right.
But it seems like that they denied him his constitutional right to freedom of speech if they didn't allow the word terrorism during the trial so he could defend himself against it when the government officials were calling him, listing him as a possible terrorist on the outside.
I don't know about the use of it that way.
I never heard of it.
That's the case here in Onondaga County?
Yeah, right here in Syracuse, federal building.
Can you walk us through the process of being a guest on one of these shows when the booker calls you, tells you whether the booker tells you what you're going to be talking about, when you find that out, what do the producers provide to you as research, how much of it's your responsibility to try to get up to speed on what happened today in the Kaylee Anthony case or whatever it may be. But how do you prep before that red light goes on?
Sure. I prep a lot of different ways, and oftentimes I begin with the kind of show. Most of the shows I do are live. Only one is taped to live, which is Showbiz Tonight. In other words, we tape it in the afternoon and it airs that night and the following morning. But all the other shows I do are live. If it's a show like the headline news shows or the Fox business shows, many of those shows I already know what's going on in the case. And so I might bone up by reading a few news articles or what have you. But a lot of times I come at things from the perspective of society and politics. And so I'm always all over the place with my comments. But when it comes to a show like True TV, which is a 2-hour show where you are in the courtroom following an actual trial, then I definitely bone up in a different way. Oftentimes the producers will send me the pleadings from the case. I'll get motions, I'll get complaints, I'll get briefs that were filed, I'll get affidavits, I'll get the arresting police report, I'll get the indictment, and then they'll also give me newspaper articles from the local area paper where the crime occurred. So I'll usually research that, and then what I do is I also will research cases that were similar. And try to find out, what was the outcome in that case? And what made the outcome different or the same? Was there some major evidence that was admitted or what have you? Is usually how I do it. Yeah, so I'll get the call, and sometimes they'll say, we need you today. And I'll say, well, what are we covering? And they'll say, Octomom, which is what they love these days. And if I feel confident that I know exactly what's going on, or I already know what my opinions are on this case, and I feel strongly about this case. I mean, one of the things that a lot of people ask me on this case is this woman trying to be a celebrity or what have you? And I always say, no. But shows like that where it's 1 hour, and it's not geared towards in-depth legal analysis, then I read newspapers and I stay abreast on it. But if it's a show like True TV where the legal analysis is in-depth and, someone wants me to kind of do a mock opening statement for a trial or ask whether or not what is the best defense here, then a case like that I usually will do a lot of research for because I have a lot more advance warning too. Because with True TV, the trials go on for a while. Some of them go on for 2-3 weeks. Some of them go on for 2-3 months. So they know what they're covering. So that's how they can get their hands on the pleadings and what have you.
And just to follow up, how much of that, how much of the invitation is conditioned on your point of view? In other words, do they vet you for which position you will represent once you're on camera, or do they just know you well enough that they know you'll be doing Octomom defense?
Yeah, they know that I'm pretty much always toe the defense line. But let me tell you what they do. Some shows, which shall remain nameless, will do a pre-interview where the producer would have come up with some questions, as to what do you think about this? What do you think about that? And, reports are showing X, Y, Z. What is your, outtake? So you give this wonderful answer and you give these great, well thought out, reasoned answers. Then you get on the show and the lights come on and the anchor steals your answers. So I've learned to keep it short and simple when they do these pre-interviews. Yeah. So they kind of, I'm like, that sounds familiar, So I try to keep it simple when they do those, yeah.
But it's not the case that someone listens to your answer to this question and say, oh, I'm sorry, we're not going to use.
Oh, no, that's never happened. Yeah, no, that's never happened. That's never happened, yeah.
I was wondering if you could comment as an attorney on the role of attorneys speaking to the media, because in effect, attorneys that are speaking to the media are kind of perpetuating this barrage on defendants.
Are you talking about attorneys who represent the actual defendant or in general?
What
Both.
you do and actual people who are representing parties in the litigation.
I actually disagree, and that's because, and mind you, let the record reflect, I'm not paid when I do my TV stuff yet, but just want you to know that. I actually disagree. I think that as a society, we've always been enthralled with the legal system. We've always talked about it, and I don't think that there's anything wrong in discussing legal issues because people want to know. I think that we live in a society that is governed by laws, and it's important to talk about them. I mean, I don't think an attorney talking on a TV show is any different from a Law and Order show or People's Court or investigative shows like law, different shows or anything like that. Especially, a lot of times when I watch this stuff, the lawyers are really just explaining what the law is and what you can or cannot do. And what I've noticed is, in terms of coverage, is that a lot of that has kind of been thrown out of the window. In other words, you have media coverage of photographs that have, we've obtained a photograph of what have you. Well, was that photograph going to be in evidence? Like, is this something that can, get someone convicted or kind of assist them with their innocence? And so by having an attorney discuss that, like, do you know that, by making this photo public that you are harming this person's right to a fair trial because this photo would have never been admitted into evidence because it hasn't been authenticated? Like, that's one of the reasons why I don't think that an attorney contributes to this in that way. Like, I think it's important to have that voice.
We have time for one more question. And I'll ask it. Do you ever have the sense that when you are on one of these shows that you're kind of working against where everybody else on the show wants to go?
Yes.
And do you feel pressure to kind of go along and say, to participate in this kind of trial by media that takes place? And if you do feel that pressure, you don't go along. Does that make for good TV, or does that limit your prospects for future punditry?
I really don't know. I mean, that I do have a law practice, so I do have a day job. so that's one. The pressure isn't there from that perspective. It's certainly easier to toe the party line because you'll get on one of these shows and they'll have 4 people via satellite and they're all saying the same thing. But from my perspective, they're all wrong. So if I feel they're wrong, I'm going to let them know that. So that is oftentimes my perspective. Now, there are times when I do agree, but it's because I agree. But oftentimes, you definitely feel as though there's almost this kind of like witch hunt. And once the ball starts rolling, it gets faster and faster and faster, and you have people calling in, this is outrageous, I can't believe this woman is doing this, and what have you. And then the anchor is like, yeah, that's right, off with her head. And I'm like, wait a minute, like, first of all, and I get a lot of flack for it, that's for sure. I really do. But I think that's the point, and it kind of goes to your question, is to kind of remind people, hello, there's actually a system here in place that we should allow to play out. And I think that that's the problem, is that there's a rush to judgment without allowing the system to play out, that I think is potentially dangerous. And until you're that defendant, I think a lot of people don't really understand it. You know, I mean, I think if anyone talks to those 3 students at Duke, you know, the 3 students at Duke, they'll get it.
Thank you very much.
Thank you.